Please, Your Lordship. My Lord, I beg to mention item number 6, 7, and 9, my Lord. I'm led by Additional Advocate General, my Lord. He's on bereavement, and he should, my Lord.
Bereavement?
My Lord, his mother passed away.
Oh. When?
On, my Lord, Tuesday, my Lord.
Tuesday?
Monday evening. Day before yesterday, my Lord. Today is Thursday. Tuesday, my Lord, Tuesday evening.
On preempted by Miss Arkuli, Leonard GA, seeking accommodation in this matter on the ground that the Leonard AAG, Mr. Andy Shulai, who's conducting the matter, is in bereavement. The same not be objected to by the petitioner. That is adjourned. This is up to 2 weeks. Priority number.
May I please, Your Lordship? Lordship, I beg to mention item number 12. I have informed the other side. This matter may kindly be taken up after 2 weeks, my Lord.
12. You are appearing for?
I am for the petitioner, my Lord.
What about 13?
13 is a connected matter, my Lord. For both the matters, I am seeking adjournment.
You say only 12?
Yes, ma'am.
No objection.
Mr. Leonard Counsel, hearing for the petitioner, has sought for accommodation in this matter on the ground that the Leonard conducting counsel, Mr. Esten, is indisposed on grounds of personal difficulties. The same not be objected to by the respondent. Pray allow. This is matter up to 2 weeks.
Highly obliged.
I obliged.
Please, Your Lordship. Should I beg to mention item number 5 on the hearing list, Your Lordship?
My Lord, I have no objections.
On premier by the petitioner, list this matter up to 3 weeks.
Deeply obliged.
Supplementary 1, cause list, item number 1.
My Lord, may I pray the matter is taken up end of the board, my Lord. Senior counsel.
No, actually,
Yes, my Lord.
This matter has already been heard. There was a confusion.
Yes, my Lord.
When there are two
Yes, my Lord.
same petitioner,
Same petitioner, two cases.
different
case.
So when you made the submission,
Yes, my Lord.
when the next matter was taken up, you said same, which means same facts, same.
Yes, my Lord.
So there the confusion lies.
Yes, my Lord.
I've gone through the papers. So I've heard the parties in this.
Yes, my Lord.
Order will be
Passed accordingly.
passed accordingly.
Much obliged. Much obliged.
And Mr. Sel,
Yes, my Lord.
on this law.
Supplementary cause list, item number 1.
So as far as this is concerned, then you have to advance your argument.
Yes, my Lord. That one is bail application number 50. Yes, my Lord. End of the board, my Lord. Will kindly accommodate us.
End of the board.
End of the board. Much, my Lord.
And daily list, item number 1.
May I please, Lordship? Lordship, I have filed my affidavit of service, Your Lordship. And Your Lordship, as far as the rejoinder is concerned, I'm praying for 3 weeks' time, Your Lordship.
Two. Mr. Leonard Counsel appearing have you filed your power? Yes, has submitted that he is entering appearance on behalf of the respondent number 2. What about 3? Who's 3? You are for 3. The Leonard Counsel to the respondent 2 has also submitted that he may be allowed to file the counter affidavit within the next date fix. What were the others? Have you filed your?
File, my lord.
You
Your
have
Lordship,
yet to file the
pre-filed
rejoinder.
rejoinder.
Mr. Learned Counsel for the petitioner has sought for time to file the rejoinder to the counter affidavit filed by the respondent number 1 and 3 respectively. Matter is posted after 2 weeks.
Item number 2.
Lordship, nobody appears for the petitioner.
None appears for the petitioner. From the records, it is seen that on the last date fixed for this matter, no counsel has made appearance on behalf of the petitioner. It appears that the petitioner has lost interest in this matter. Accordingly, petition is dismissed.
Much obliged, Lordship.
Non-prosecution.
Much obliged, Lordship.
Item number 3.
My lord, we have just received the case diary, my lord. Let this matter come up tomorrow, my lord. We'll just go through the case diary, my lord. We just received today morning, so need some time to.
Not tomorrow, because tomorrow I'll be leaving early. I have to go to an unofficial.
As your lordship,
Will you return after one case now?
Monday and Tuesday I'll be out of station, Lordship.
So take it up on Wednesday.
Wednesday,
25th.
Wednesday, Lordship.
On premier by the parties, this is matter on 25th.
Yes, ma'am. Highly obliged, my lord.
3 and 4.
3-4.
Item number 8.
Penny 7. Purple.
Please, Lordship. I'm praying for some accommodation, Your Lordship, in this matter, Your Lordship. Senior Counsel is some difficulties, Your Lordship.
Have you gone through the order sheet?
Your Lordship.
Just list the number of dates that you have sought for accommodation. You cannot go on like this.
Lordship,
If you are not interested in the, prosecuting the matter, then say so. What is the case about?
regarding the Lordship, the export, Your Lordship, we have filed some representation for the petitioner.
Is it an issue of subsidy?
Yes, Your Lordship. We have filed so many representation, Your Lordship, to respond on, but till then, I have not.
Once again, the learned counsel for the petitioner has sought for accommodation on the ground that the learned senior counsel who is conducting the matter is indisposed. Prayers allowed. However, it is prayer allowed. As prayed for, this is matter after 3 weeks.
Your blessed, Lordship.
Item number 9.
Yes. Who's appearing for petitioner?
They're not available. It may adjourn, my lord.
None appears for the petitioner on prayer made by the learned G appearing for the respondent. That is adjourned. Let's see after 3 weeks.
Item number 10. Supplementary cost list. Item number 1.
My lord, can I pray, my lord, if the matter can come up on any other day, because it seems they are already.
My lord, may please, my lord. My lord, this case also this more or less the same with this Clear PS 53. My lord, in this case I was charged under section 29, criminal conspiracy. My lord, in this case what has happened is that the main accused is Shokothang. Shokothang was arrested, and after Shokothang was arrested, another one lady was arrested, Ngairemi Simte. Ngairemi Simte was arrested because she was found in contact with the main accused person. And after the arrest of the Ngairemi, my wife was arrested because the police found that my wife was in contact with Ngairemi. When my wife was arrested, I was also arrested because I am the husband of Lene Hoi. That is the case. There is no statement under 161 recorded. Section 67 of the NDPS not recorded. Nothing was found from my disposition.
Have you gone through the CD?
Yes, my lord, the CD has already
See,
produced.
Mr. Sharon, you have to be careful when you say that, because you have to check the record or you have to confirm from your client. The earlier case also, you said the same thing. Whereas when I produced the case diary, on the very day that he was arrested, his statement was recorded. 161 was recorded of that accused person.
That copy was not supplied to me by that.
Actually, they're not.
Yes.
You could see what you could have done is you could have got instruction from your client. You could have inquired from him. Maybe he didn't understand what is really asked for. But then when I went through, his statement was recorded.
My lord,
But anyway, this case we don't have to yet to go to the case diary.
My lord,
Here, I think, my lord, it is a commercial quantity and some admission to the statement is also there. Yes, my lord. So,
yes, my lord, my humble submission, my lord. Kindly come to this charge sheet, page 39. Page 39 of the charge sheet. This charge sheet, page 39. May I read out this second paragraph? Under the above facts and circumstances, the investigation clearly proved that the accused person, namely Sokothang Tothang, of possessing, transporting.
You're reading page 39.
39, page 39, second paragraph.
Yes.
Transporting, import, interstate illegal contraband, thereby proving under section 21C NDPS Act, and Shri Khailen Haukip, Shri Mati Lenehoi Haukip, Miss Ngairemi Simte have conspired among themselves, thereby proving under section 29 NDPS Act. You honor to say, my lord, the police, I was not in use of mobile phone. I never used mobile phone. So when I was arrested by the police, no mobile phone was recovered from my possession. Only the mobile phone of my wife. As I submitted earlier, my wife was in contact with Ngairemi Simte because they were from the same village. Only after my wife married to me, she was shifted to Churachampur. So there is no any prima facie evidence to prove that I was in conspiring Ngairimi Simte when no mobile phone is recovered from my possession. Even this section 29, the offence of committing criminal conspiracy is also not relevant on my part. For me, the mobile phone was recovered from the wife of my wife, not from me. I was not using mobile phone at any point of time, my lord.
What does section 29 says? How do you determine conspiracy?
Section 29 Sorry, my lord.
Yes, please read out section 29.
Whoever abets or is a party to a criminal conspiracy to commit an offence punishable under this chapter shall, whether such offence be or be not committed in consequence of such abatement or in pursuance of such criminal conspiracy, and notwithstanding anything contained under section 116 of the Indian Penal Code, be punishable with the punishment provided for the offence.
So, you see, this section implies that if somebody is charged with an offence under any other section under this act, so abetment of the offence alleged and conspiracy would carry the same punishment.
Yes, madam.
So if this is a case where the offence is under section 21C, so by extension, if you are also charged with an offence of under 29, so it can be assumed that you are also guilty of the offence under section 21C. Of course, that is prima facie. So to that extent, what we can understand is the provision of section 37 would be applicable to you.
Please.
So if that is the case, then you have to prove, you have to convince this court that you are innocent. So if the court can presume or assume that you are innocent, then so be it. Of course, you say that the only link is with the mobile phone, which was not seized from you.
Please, my lord. My lord, this case, the instance happens on 15 June 2023 at Nonsning. So when the incidents occurred, I was not there. I was not present in the vehicle, and I was arrested on the 3rd of August after more than a month. After more than a month, when the police recovered the mobile phone of my wife, with Ngairimi Simte. So when the police came, without any prima facie evidence proved, I was also tracked away. So I pleaded, I requested the police that there is no any prima facie, what is the offence I have committed? When there is no anything to show, to prove that I have committed such offence, so the police simply track away that you will just have to answer whatever the charge is against you in the police station. So later on they arrested me and they booked me in this case. My lord, my humble submission is that no mobile phone was seized from me. I was never used in this mobile phone. The mobile phone was used by my wife. She was in contact with the other friend, because at that time the violence between the Metis and the cookies were at the peak. So every day they were in constant contact. regarding the violence, collecting the information. I was not in use of mobile phone. There is no any relevancy to arrest me in this case, and there is no any credible evidence to prove that I was involved in this case. Simply on the ground that I am the husband of Lene Hui, my wife, I cannot be arrested. We are husband and wife, but this mobile phone was recovered from my wife, not from me. So the police arrested me also. I pleaded my innocency, but they were not ready to consider my prayer. So this is the case. My lord, I have 4 children who are all minors. They are struggling by themselves for survival. There is no relatives out there to help my children. And my house also has been damaged in the recent flood. So my children are suffering. So my humble submission is that I may be kindly allowed to go on bail. I shall always appear before the Honorable Court as and when required. I will never abscond in these events. I am enlarged on bail, my lord.
In fact, Lordship, while my friend was submitting, Lordship had clarified that part. So I don't think so I need to further clarify, except for a bit of illumination into that aspect.
That is the position of law.
Absolutely, Lordship.
Now let's go to the facts.
Lordship, the facts remains very, very clearly both of his client. If you go through the CD part, the relevant part of their statement, not only his client but then the recipient, who is not before the court. If you see the 3 statements of all the 3 people, the recipient, who is not before the court, clearly, categorically made a statement that the couple, the wife and the husband duo, the wife had informed her that the consignment is coming and she is supposed to receive. That is very, very crucial, Your Lordship. So, prima facie, the recipient has clearly admitted that I don't know anybody, I am staying in Shillong. I got a call from the wife who stated that the consignment has left Manipur. Why Mizoram? Kindly receive it. Now that is crux which clearly comes within the meaning of 29. Conspiracy and abetment. And anybody, Lordship, if you read 29 again, the legal position is anybody who is part of an abetment or conspiracy are guilty of the offence committed. In this case, Your Lordship, the other accused, again, who the main accused, who has got his independent status so far the case is concerned with regarding to travelling in the vehicle, section 50, witnesses. I am not arguing that because that accused is not before the court. Neither we are contemplating to oppose or get into the facts regarding what is his status regarding bail. And my friend is very correct when he says he was not travelling in the vehicle, but that is not the case before the court. Nobody is arguing like both the accused were travelling in the vehicle. Their case comes within the meaning of abetment and part of a conspiracy. Now, prima facie, the court has to see whether abetment or conspiracy has been, prima facie has been established on the basis of fact. Now, at this stage, Your Lordship, fact would be what is the available statement when the charge sheet was filed. What was the facts which will constitute a prima facie case of abetment or conspiracy? My submission, Your Lordship, is both the couple, both the dual husband and wife and the recipient statement, which was also part of the charge sheet, clearly establishes prima facie that they were part of the consignment from where it will be received and where it will be delivered. And then, Lordship, if you read that part with the main accused is not before the court statement, which is there in the diary, case diary, the main accused from whom the consignment was seized, where section 50 was complied, he further has corroborated that he is a poor man and he had no idea, he had financial crisis, and there was information given to him, kindly take this, go to Aizel, from there you travel and go and give it to the recipient. So if you see the main accused who is connected with 50 and the husband-wife duo and the recipient, if you see the evidence of all these 3 people or 4 people, Lordship, at this stage, prima facie a case is made out of an abetment. Prima facie case of commission of offence is made out against the other accused who is not before the court. for whom section 50 will be applicable. So for both the accused before the court is concerned, the entire evidence, if is appreciated, a prima facie case of abetment or conspiracy for seeing that the consignment reaches his desired place is clearly made out. It was only when this information reached police in the transit in the petrol pump, where the vehicle was stopped, search was made, and on searching, the so-called drugs was seized, and which was tested there, prima facie it was found. So the chain reaction clearly says, Your Lordship, they are part of that conspiracy. At this stage, Your Lordship, as Section 37 has got...
What is the statement of the main accused? What does he say?
Main accused, Your Lordship, is clearly stated. He gave the consignment, Your Lordship.
And you read out his statement?
Lordship, yes, 161 statement. He gave the consignment on 11/9/2023.
Which flag here?
Lordship is Lordship. I don't. The statement is there. Lordship, kindly just if you can pass the CD, we'll just assess the court.
You don't have a copy with you?
No, Your Lordship. This was one copy. We'll just come to it.
Anyway, I've got his statement here, but just see.
Just like main accused. Yeah. Lordship is what the right page. Right from the portion where it is. Okay, Lordship. Should I read out the case diary? In the court?
Why not?
With the permission of court. Absolutely.
That will convince him. If not anybody else.
Lordship, not for any reasons. Lordship is aware that as PP we are not supposed to read out.
See, that is true. But when the matter is
charge sheeted.
When the matter is before court, and even as you pointed out, it has been charge sheeted.
Yes.
So that becomes, you see.
So we will be grateful, Lordship. If the Lordship wants it, then yes. Otherwise, Lordship, we have learned it from your Lordships even during our earlier days that we can't read out.
No, you can't. You can't. Not, you see, normally or...
Normally, yes. No, with the leave of the court, absolutely, Lordship.
But that is on the basis of the submission made that the accused person has no connection whatsoever.
We are grateful, Lordship. At least Lordship wants to refute that particular submission by a supporting fact. On the issue of fact, yes. I was contacted by one person who's identified himself as Shri Kahlen. He called me to come to my residence. On reaching his residence, I was told that there is a construction work at Shillong and he wanted me to work there, and as the situation in Manipur was very bad, and I agreed. As I accepted to go to Shillong, I was given one black air bag along with some of his clothes in it. Kahlen told me that the bag to Shillong, and that on reaching at Shillong he will contact another person to pick up from the parking lot along with the consignment. Shri so-and-so Kahlen, his client, told me to move to Shillong via Aizawl, Mizoram. He also told me that after getting the work done, taking the consignment to Shillong, he will give me money. As I agreed, as I have to pay the school fees of my son. So I agreed. I left Manipur and only Shillong at 9 p.m. and I shall stayed at hotel for the night. The most relevant part here is the black bag and the consignment. Now, admittedly, if we read the deposition of this person and when the seizure was made, the black bag was seized, and whatever came out from the black bag was the consignment. And there's an admitted position that once the consignment is delivered to somebody will contact him in Shillong, and the money will be paid. So consignment, black bag, money will be paid. These three facts clearly proves that the other accused who is not before the court, was aware as to what he was supposed to do. He was also aware what was there in the bag, and he was also aware that where the bag has to be delivered, and he was also aware once the bag is delivered, he gets back to the client, the petitioner here before the court, and the money will be given. And the word clearly says this consignment. So, Your Lordship, the facts are self-evident. They speak for themselves that it comes clearly within the meaning of abetment and part of a conspiracy. So, whatever happened on 15 July is immaterial. Whatever, the issue of phone call, whether it was seized from him, nothing was there, case CDR record is irrelevant for the purpose of bail matter, because prima facie the abatement part has been self-evident. So his argument that he submitted that I am no way connected, I'm afraid, Your Lordship, on the face of facts before the investigating officer, and which is part of the charge sheet, that stands refuted, because the facts speak otherwise. So if that is the situation, Your Lordship, a case of prima facie case has been made out of section 29. And at this stage, there are two requirements under section 37. That if a prima facie case, court, as the Lordship has, there are number of judgment court as part, court normally at the end of the judgment says this will not affect the merit of the case. So prima facie means whether there are materials to connect, not materials to prove that will be part of the trial, but materials to connect on itself whether prima facie can court take a view that yes, there is a case of abatement. In this case, Your Lordship, the statement clearly says, and their own statement corroborates that. And then if you see this statement with the recipient, who is also not before the court, her statement, she clearly says that she was asked by his client that some consignment will come. And they don't know each other. The interesting thing is that the main accused from whom section 50's compliance was required and from whom the consignment was seized, he had no idea to whom he is supposed to give. So the main person, Your Lordship, the main person who is the master in connecting the consignment from the place of origin to the destination is the doer couple. If you remove that, the whole case will collapse. I don't know, I get this and I give it to somebody. But these are the two husband and a wife, on the basis of evidence, clearly shows that they were mastering and they were monitoring as to what is to be done. So if the trial goes on, Your Lordship, if that fact of the matter comes out in evidence, it will be an open and shut case as to. And I'm not arguing the other part of it, whether it's got children or not. That can't be a ground for bail or reject or not bail, as the trial court also has had social welfare department can take care of it, and that is not a ground under section 37. Section 37 says prima facie, and they will not repeat the offence. And prima facie, Lordship, is laid down very clearly. Prima facie is on the basis of available materials. And I have pointed out from the case diary, Lordship, prima facie material exists. In the second part, Lordship, whether he will not commit any offence, Lordship, the impugn order which is relied clearly says he was involved in some other case, and there are two situations before this court, Lordship. There are two cases where they are involved, and there is no, once there are two situations, that means they are repetitive offender. Of course, there are matters, some other matters they were involved in it. That is not before the court right now, but prima facie, Lordship, there are two matters they involve, and there's a ring in operation as to how this thing has to be done. And last, Lordship, very important from what emerges from this fact is this: they are the mastermind. They are the mastermind to negotiate. How they involve, which way they involve at this stage, Your Lordship, only when the other witnesses comes up, and what role has been given, and then very important, Your Lordship, the fact of what the other accused under section 50 said. The actual picture of the case, of the trial, or the evidence will get a limelight only in 313, or before that when he chooses to come in the witness box, or no, or not. If not, then he'll be confronted in 313. So that is a very crucial stage of this case, not at this stage. Even if not, Your Lordship, at that stage, supposing he says, no, I didn't never make this statement. Supposing he says that, then the choice before the court would be whether he was making a false statement before the court on 313 or whether this was a false statement. Then we will have to look at the other part of it. The recipient lady, the accused under section 50 and on both the statement. All these people, if they come to the witness, if they've come to the witness box to answer 313, then court will have to look as to who was telling the truth and who was lying it. So that is the crucial stage so far this case is concerned as to what will be the level of abatement involved, what will be the level of a conspiracy. Before that, if they come in the witness box, things will be different. If they don't and court has got no option, then the issue would be in 313 what they reply. If they give a false statement, Lordship, court can discard and see the evidence which is applicable. If we look at the trial in this stage, this is not the stage for this Honorable Court to grant bail, especially when the conspiracy angle is involved, abatement is involved, and the accused before the court appears to be the main movers and shaker as to how things should be done illegally. So my case, Lordship, this is not a fair case. At least at this stage, this is not the case, not a fair case.
May please, my lord. Please, my lord, I may be kindly allowed to give a reply to the submission given by my learned friend. My lord, my friend has given a submission out of the purview of this case. My lord, my submission is that my name is not reflected in the FIR. Panchanama was executed on the spot. There also my name is not reflected. My statement is not recorded under section 67 of the NDPS Act, which is very important. That 67 of the NDPS Act, my confessional statement will reveal the entire episode of this case. But that was failed in this case. And Your Honor, here in this case, my friend has learned friend has submitted that my wife was in contact with the other lady. That I'm not disputing that, my lord. She was in contact with the other lady. What I was not having the mobile phone. I never used mobile phone. That was the contact between my wife and the other lady. I was out of the scene. I was not aware of this case, and I have no other criminal records. This is my first case. And when the police come, they also arrested me and booked me in this case. And this, my lord, here in this case, the prosecution witnesses, number one, who is the complainant, also has been examined, and he has not stated anything against me. He has stated purely this offense committed by the accused number one, Sokotang Totang. I have this cross examination of the PW1. If Your Honor allow this, my lord allows me this, I would like to read it out. This is page 51.
Yes.
51. As cross examinations of this cross examination of yes. It is a fact that Exhibit 1, the name of Shri Kailan Hokip and Lene Hui Hokip have not been mentioned. I was not the one who had reduced into writing the source of information received. I cannot say if the independent witnesses are locals from that area or not. It is not a fact that when the accused said no independents were present. It is a fact that the vehicle in which the accused was traveling is a commercial vehicle. It is also a fact that there were some other passenger traveling with the accused on the day of the incident. This is with regards to this Shokotang Totang, my lord.
Yes.
I cannot say if those passengers were summoned by the IO to the police station and as to whether their statement were recorded. It is also the fact that recovery of contraband is not produced before the court today. I cannot say the quantity of the drugs which was sent for FSL. I was not present at the time when the samples were drawn. I cannot say where the panchanama were prepared. It is also the fact that I do not know the mobile numbers of the accused Kailan Hokip and Lene Hoi Hokip. I do not know the statement of the accused Kailan Hokip and Shrimati Hokip were recorded or not by the IO under section 67 of the NTPS Act. It is a fact that I do not know where the accused person Kailan Hokip and Shrimati Hokip were arrested. It is also the fact that apart from filing Exhibit 1, I have no conversation. I am not conversant with the facts of the case. So even the BW1, who is the main eyewitness, has not stated anything against me, my lord. In this entire case, this IO has charged it against me under section 29, alleging that I have committed a criminal conspiracy. Your Honor, that is a false and baseless allegation. I have not committed any criminal conspiracy. That my wife was having a mobile phone. She was in contact with the other female co-accused. So everything was everything that is putting allegation by the police was that my wife who made a call to the other co-accused. I was not, and I do not know who is this Sokotang Totang also. I have never come across this man. I never contact with this man. And my wife also was not in contact with the Sokotang Totang. My wife was in contact with Ngairemi Simte, one of the co-family accused.
Yes.
Yes. So, Your Honor, my lord, that there is no prima facie evidence to prove that I was in contact with the this co-accused. That the police statement recorded given by the police may not be construed or may be taken as this absolute truth. This all the statement given by the police are false and baseless. And it is, my lord, I pray again that I am as a father of 4 children. I have been languishing in the jail for 15 months. Until today, only 1 witness has been examined. So no other witnesses are appeared. On every date fixed, they have failed to appear in court. And whereas children are suffering, they have no one to look after. Because of this violence, every relatives, all my relative has been scattered here and there, and my children are suffering. You know, I'm not praying for acquittal. I'm praying for enlarging me on bail, and I shall not abscond in the events I'm enlarged on bail. I shall always appear before the honorable court till the final disposal of the case. That's all.
How many witnesses have been examined, you said?
Only 1.
Only 1. How many witnesses are there?
6 altogether. 6, my lord.
6. When was the witness last exam?
2nd April 2023.
Have you checked on that?
This is 24, my lord. Sorry.
Last time I have requested you to check on these.
Lordship, yes, we have informed you, Lordship. The next date, the information received, Your Lordship, is the next date fixes on 30 September. 30th. Before that, 30th, Lordship. Before that, there were a number of dates, but for August also there was date fixed. But for some reason, Your Lordship, or the other, the matter, either the witness, some officers were in duty, and as usual, Your Lordship is aware of it. So there is sufficient explanation and reason, Your Lordship. We have given the copy, correct? We have given the copy, Lordship. The orders and all.
Do you have any authority on Section 29?
Section at this stage, Your Lordship, if Your Lordship wants, then we can give. But at this stage, I don't think so, Your Lordship, would require to, except if the court feels that the word abetment or conspiracy. As I submitted, Your Lordship, that stage is not
just for the interest of this court.
No, Your Lordship,
Since the accused has been charged under Section 29, so there must be some basis for that.
Lordship, so far, I agree with the Lordship. Had it been the case where we are arguing an appeal after acquittal or conviction, things would have been very different. At this stage, Your Lordship, yes.
True. At this stage, we are not going to.
At this stage, only the issue of prima facie.
Only the issue of prima facie.
Prima facie.
But even then,
yes.
How do you come to a finding that he is to be charged under Section 29 or any section for that matter, if there is no evidence in that respect?
In this matter, Lordship, his submission was there is no evidence. Lordship, I have read out right now.
The submission is
the factual part.
He would maintain his stand.
Yes, I'm maintaining, Lordship. My stand before the court is this: the investigation was done and the charge sheet was filed, where the statements are part of it. Had there been no statement, my whole argument would have been very different, Lordship. Now, this statement will have to pass the test of oath when the other witnesses come, and a situation where the accused will be asked to bring witness to prove or disprove, and then the final stage will be 313. Had this statement not been there, Lordship, there was no question. And now Lordship, can you appreciate why we can't get a direct answer on that?
Yes.
Lordship, can you appreciate the main accused from whom the drugs was seized?
Yes.
If his case collapse, the prosecution fails to prove that, all other structure, all other people connected with it will collapse. Now, the accused before the court are not directly involved in transferring or in possession of the consignment. So that's where the tricky facts so far this case is concerned. They are directly involved in mastering as to how the consignment should travel from Manipur to Shillong. So now we have a situation under 29. The two words is very important, Lordship: abetment and part of the conspiracy. So the common sense approach, Lordship, at this stage would be simple meaning of abetment would be somebody who facilitated or who played a major role. He may not have been accused directly, but he facilitated. Admittedly, Lordship, if you read and deposition which I read out, it's an open and self-evident fact that both these accused are mastermind in abetting. And the law is very clear, Your Lordship, if you are abetting and a part of a conspiracy, it's almost like you're committing a crime, and which is under the NDP Act, which itself is an offence.
What is the quantum of punishment?
Punishment, Your Lordship, commercial. It should be
29.
29.
20 years.
20 years.
29 is, no, 21, 21C is 20 years. 29, of course, will follow. It will follow.
Shall be not less than 1/2 of the minimum term, but which may extend to 1/2 of the maximum term of imprisonment with which he would have been punishable in the event of his being committed such offence, and also with a fine. So, Lordship, this stage will come only when the main accused. That would be a separate argument on the sentencing part and the level of involvement.
Yes.
So, Lordship, as a summary, Lordship, we are not in appeal before after a conviction. Maybe these issues would have come. Right now, it's only in the issue of prima facie. Any Lordship is aware, Lordship, prima facie in a bail matter is a very tricky area.
My lord, there is no prima facie against this evidence against me in this case. This is the allegations of the police. There is no prima facie evidence at all against me in this case. The police has charged me, charged me under section 29. But there is no prima facie evidence. Mobile phone was never recovered from my possession. It was recovered from my wife. And there is no CDR. CDR has not been provided. And when in the absence of the CDR, where is the proof that I was in contact with the main accused person or with this Ngaire Simde? There is no proof. The police alleged that I was also involved in this case, but I said no. So my wife was in contact with the other female accused with regards to the violence. I was totally out of the scenario, the scene. The police also falsely arrested me and put me behind the bar. I have been pleading my innocency at the time of arrest, but the police never considered my prayer. When there is no mobile seized, when there is no CDR, when there is nobody has seen that I was calling to the other co-accused, no eyewitness, even the police has not seen, and the main accused has never mentioned my name in his statement. That was the allegations of the police. That cannot be considered as absolute truth. It is my lord, I pray that I was totally out of this case, and there is no any relevancy to arrest me in this case because there is no credible evidence proved by the police. That is my involvement in the instant case. So there is no mobile. When the mobile phone is not recovered, where is the question of criminal conspiracy committed by me? And when there is no CDR, where is the record? Show at least to show before this honorable court that yes, this is your mobile phone number. You have been calling this number on that day. It is not there, my lord. So when there is nothing on record, how can the police blame that I have committed this criminal conspiracy under section 29? So my lord, this is totally false. I have never committed any offense. I have admitted yes that my wife was in contact with other female accused. It doesn't mean that the contact offense committed by my wife cannot be liable to me also. I never use mobile phone. I never contact anybody. So this, my lord, I may be kindly allowed to go on bail.
I've heard the parties are passing orders.
Much obliged.
ये हो गया ना कविता खबर तो
Much obliged.
daily list, item number 1.
May it please your lordship. May it please your lordship.
Yes. Then
My lord, I have filed this appeal against the order dated 14 August 2024, by which my writ petition was dismissed, considering that the interview panel consists of the expert and the contention of the appellant that the interview board has been wrongly consisted was rejected. My lord, the appellant has raised the objection on the expert
appeal
on
is
the expert sitting.
the appeal has been filed in time.
Yes, my lord. Yes.
We'll admit the appeal. Who is appearing for the other side?
My lord, I'm appearing for the state. There is a private respondent as well.
Who means you take steps for issue of notice?
Yes, my lord.
What, Miss Counsel for the appellant? This was already written. Why do you give giving numbers? Because this number is already. Appeal admitted. Ms. S. and Leonard G. has entered appearance on behalf of the respondent number 1. The learned counsel for the appellant would has submitted that she may be allowed to take steps for issuance of notice upon the respondent number 2. Pray allow. This is let notice be issued, returnable within 2 weeks. This is the matter thereafter.
Item number 3.
Highly obliged.
Wait, please, my lords.
At the appeal by state, my lord.
Yes.
But there is a request by the learned senior counsel for the respondent in this matter, my lord. For adjournment, my lord. I received a phone call that he is in some difficulty, my lord, in item 3 and 4. This counsel for respondent.
May it please, my
So
lords.
making it easier for the counsel.
Lords, I'm seeking for an accommodation, a short accommodation.
You don't need to seek. It has already been sought for.
Lordships, I'm praying if this matter
Made by the respondent, this is matter up to 1 week.
Lordship, 27th, subject to your lordship's convenience.
Your lordship may have it on 26. 26 is also
26. No, we may have 26. We have a program. Is it on 30th?
Lords, item 4 would go accordingly. Not
Yes,
appear for the app.
fine.
Highly obliged, lordships.
Item number 5.
My lord, we would like to pray for 2 weeks' time. Mr. Yobin is unwell, my lord.
This matter was, my lord, fixed for producing of authorities by Mr. Yobin. So, lordship will see 12th June 2024's order. If those authorities can be supplied in advance before next date of hearing, 12th June 2024 is also.
Yes, already. See, look at 12th June. Yes, has produced. He has produced.
After my lord, matter came.
Yes.
And then the matter, my lord, in fact, argument was heard also in this matter, but it was by the then Chief Justice, my lord.
So we'll have to hear the matter again.
Yes, I did. So we'll have to hear the matter.
on premier by the appellant seeking accommodation on ground of personal difficulty on the part of the learned conducting counsel, Mr. POB. Matter is adjourned. This is after 2 weeks.
Much obliged.
Item number 6.
Yes, who's appearing?
Your Lordship, Mr. S. Thapa is supposed to be appearing for the appellant.
None appears for the appellant. On pre-bid by the respondent, this is matter after 1 week.
Item number 7.
May I please, Your Lordship? Lordship, I kindly pray to adjourn the matter. Kindly fix the matter after 1 week, Your Lordship. Counsel has some personal difficulties.
On pre-bid by the on behalf of the learned counsel appearing for the respondent or for the appellant. On grounds of personal difficulty, matters adjourned. List is here after 1 week.
Obliged, Lordship.